because we have an election petition matter in this same court that is ongoing for 5 years plus. So if this matter keep on going for months or maybe a year, what will happen to the country? Right now the country is in limbo. We have all these parliamentary committees held hostage presently. The budget is coming up. The budget is coming up. What will happen? You need an opposition leader there. How will we move forward? We need an office so that persons can come in. They're given a budget of $30-something million, a pittance. Can you believe the office of the First Lady get a bigger budget than the opposition leader? The office of the First Lady gets a bigger budget, gets more money than the leader of the opposition.
So how soon will the opposition, win, be moving to the court as indicated? Is that still on the table?
It is on the table, I think, earlier this week.
Welcome to the Deep Dive. Today our mission is to take this huge stack of legal sources on a really high-stakes extradition ruling and basically cut through all the jargon.
Right, to show you where the lines are really drawn in international law.
Exactly. We're zeroing in on the recent determination from the Georgetown Magistrates Court.
Concerning that extradition request for two very prominent businessmen, Nazar and Azruddin Mohamed.
And what makes this such a great case for a deep dive is how clearly it shows Guyana's commitment to its international treaties.
Even when they're faced with these, pretty serious constitutional challenges from the defense.
Okay, so let's unpack that. We're looking at a legal drama where the defense tried a major procedural move.
A big one. They were trying to halt the entire extradition inquiry by arguing these complex constitutional points.
Basically trying to bypass the whole evidence phase at the magistrate's court.
Right. And the court had to give a definitive answer. Can you use constitutional arguments to just stop a legal mechanism that's based on a binding state-to-state treaty?
It's a classic battle, isn't it?
Yeah.
Individual rights versus national commitments.
It really is. And for you, the listener, this case isn't just about the Mohammeds. It's about setting the boundaries for future extradition cases in Guyana. It tells us which arguments the judiciary considers, settled.
So let's get into the context. Who are the players? We have Nazar Mohamed and his son Azruddin.
That's right. They were in court on December 10th, 2025 for a decision that would really set the course for their legal future.
And what are they actually accused of? The charges are huge.
They're colossal. It all stems from a U.S. indictment that was unsealed back in early October 2025.
From a grand jury in the Southern District of Florida, I believe.
That's the one. And this whole thing is tied to an alleged U.S. $50 million gold export and tax evasion scheme.
$50 million. I mean, when you hear a number like that, you start to understand why the U.S. is pursuing this so aggressively.
Absolutely. The specific charges, they cover everything you'd expect in a major white-collar crime case.
So it feels like wire fraud, mail fraud.
Money laundering, conspiracy, aiding and abetting, and, a whole host of customs violations. It paints a picture of a really massive operation.
So how does the U.S. get Guyana to the table? What's the legal mechanism that kicks all this off?
It starts with an official extradition request, which came from the U.S. on October 30, 2025. But what's really crucial here is the legal foundation. It's not a new agreement.
It's the old extradition treaty between Guyana and the United Kingdom.
Exactly. And if you're wondering why a UK treaty is still in play, that's where local law comes in.
Right. The Fugitives Offenders Act.
Precisely. That treaty is in full force under Section 4(1) of that act. And here's the key detail for you. The act was amended, specifically by Act Number 10 of 2024.
And that 2024 amendment is a real game changer, isn't it?
It is. It means the Guyanese legislature actively reviewed and reinforced this inherited treaty very recently.
So it's not just some dusty old document. It has current, undeniable legal authority under their domestic law.
You've got it. The foundation is solid, and that fact becomes central to the magistrate's final ruling.
Okay, so with that rock-solid treaty in place, let's turn to the defense's strategy. They weren't arguing the facts yet.
No, not at all. They were trying to kill the process before the evidence could even be formally considered.
So it was their procedural Hail Mary.
They raised these extensive arguments at the magistrate's court level. The core idea was that certain constitutional issues should force a pause on the whole extradition inquiry.
A classic move to try and bump the case up to the high court right away.
That was the goal. They focused on a couple of things. First, timing. They questioned if they had to wait for what's called a paper committal before raising these constitutional flags.
Hold on, paper committal. Can you break that down? It sounds like pure legal jargon.
It is, yeah. A paper committal is just when the magistrate reviews the evidence submitted on paper by the requesting state, in this case the U.S.
So it's not a full trial.
Not even close. The magistrate just has to decide if there's enough evidence there to justify an extradition. The defense wanted to raise their issues before that even happened.
I see. So their argument was, if the whole procedure is flawed, why should we even have to look at the evidence?
Spot on. They wanted to attack the vehicle before the prosecution even loaded the cargo.
Yeah, their second line of attack.
That was focused on the diplomatic note from the U.S. that came with the extradition request. They challenged the court's reliance on it.
And they knew the magistrate's court couldn't settle these deep constitutional questions, right? This was a purely tactical step.
Oh, absolutely. The defense attorney, Roysdale Ford, was very clear. They went to the magistrate's court first to clear what they saw as preliminary hurdles.
Their real target was always the high court.
Always. They see this as a necessary step in the constitutional process for challenging state power.
Which brings us to where the whole narrative turns.
Yeah.
Because the court's response was not what they hoped for.
Not at all. Principal Magistrate Judy Latchman delivered her ruling on December 10th, and the language she used was frankly astonishing.
It was incredibly definitive.
It was. She dismissed the application, calling it frivolous and vexatious and an abuse of the process.
Wow. You just don't hear terms like frivolous and vexatious thrown around lightly.
Yeah.
That's a judicial condemnation.
It is. It's a declaration that the issues they raised weren't just wrong, but they were a waste of the court's time because they'd already been settled by higher courts.
So why risk it? If the law was so settled, why would skilled attorneys go down a path that could lead to that kind of official rebuke?
That's a great question. And it really speaks to how few procedural options they had. They had to take the shot.
Because if they could convince her there was a genuine, unresolved constitutional question,
then the magistrate would be legally required to hit pause and send the case up to the high court. They took a long shot and, well, it just didn't pay off.
So what was the core legal reasoning the magistrate used to justify this dismissal?
She grounded it in established precedent and really the fundamental nature of international law. She drew a really important distinction. She said that while a diplomatic note, the letter from the U.S., isn't necessarily set in stone, the underlying treaty agreement itself is binding.
So you can't challenge the whole treaty by picking apart the cover letter.
That's a perfect way to put it. The treaty must be performed in good faith. But the most decisive point she made was this: extradition is a state-to-state agreement.
Meaning the individual, the person being extradited, isn't actually a party to that contract.
Precisely. She said the individual plays no part in the contractual arrangement, and the implication there is huge.
If Guyana signs a treaty, that national commitment comes first.
It supersedes the individual's ability to challenge the foundation of that contract on these grounds. You can challenge how it's applied, but not the commitment itself.
Which really reinforces how seriously the judiciary takes these international obligations. What about the old case law the defense brought up? The Ditaram Authority.
They did, and the magistrate shut that down completely. This is the real aha moment if you're following the legal precedent.
Why was that?
She pointed out that the Ditaram case was dealt with before a critical piece of legislation, the Fugitive Offenders Amendment Act of 2009.
So the legislature updated the law, which made the old court ruling totally irrelevant.
That's it. It's a perfect example of how legislation can override older judicial interpretations. The magistrate hammered home that the legal landscape has shifted and everyone has to follow the current law.
So based on all of that, she saw no reason to pause things for a constitutional review.
Correct. She flatly denied the application, stating the court saw no basis to activate the referral article. She said the issues had, and this is a quote, been put to rest.
So the defense's procedural wall was just obliterated by settled law, which brings us to the path ahead. What was the immediate fallout from this ruling?
The immediate outcome is simple. The real extradition proceedings, the substantive part, now have to move forward in the magistrate's court.
And the prosecution was ready for that?
Oh, yeah. Prosecutor Terrence Williams said they're ready to proceed with the formal examination of the evidence the U.S. sent over.
So the court now shifts from arguing about procedure to actually looking at the evidence in the case. What's the date people should circle on their calendars for that?
The hearing is set to start on January 6, 2026.
And until then?
Until then, the Mohammeds have to keep reporting to the police, and they remain on their $150,000 bail.
Now, despite this really stinging loss and that frivolous and vexatious label, the defense isn't giving up.
Not at all. They signaled their countermove immediately.
What's the plan?
Rosedale Ford confirmed they're going to approach the High Court directly. They're going to argue that the magistrate got it wrong.
So they're challenging her judgment that the issues were settled in the first place.
Exactly. They're arguing she improperly exercised her discretion when she denied that constitutional referral.
So even though she denied them the referral, they're using their constitutional right to appeal that denial to a higher court. The battle just moves up a level.
That's it. The magistrate's court was a gatekeeper. That gatekeeper said no, so now they have to go to the High Court and argue why she was wrong. The real constitutional fight is just getting started.
Which brings us to the core lesson from this deep dive. What's the key takeaway for you, the listener, watching all this unfold?
I think this ruling is a really firm declaration of the strength of international treaty law in Guyana. It shows that any attempt to delay extradition using constitutional questions that have already been answered, well, it's going to be met with serious judicial resistance.
So if you're going to challenge an extradition on constitutional grounds, you need to bring something new to the table, not settled law.
Or you risk having your entire strategy dismantled as frivolous, just like we saw here.
It's a procedural high-wire act.
Yeah.
And it seems the nation's commitment to its treaties outweighs an individual's ability to relitigate old challenges.
The message is clear. Settled law is settled law.
And now for the provocative thought we want to leave you with, something to think about before that January 6th hearing. The magistrate's ruling was powerful. She said these constitutional issues were settled, put to rest. So now that the defense is heading to the High Court anyway, the question is this: what new substantive constitutional grounds could they possibly argue that haven't already been addressed? They have to find an angle that justifies overriding the state's treaty commitment. You want to watch those proceedings very closely.
The procedural battle might be over in the lower court, but the constitutional war for precedent is just beginning.
Thank you for joining us for the deep dive. We'll be watching this case as it unfolds.